Welcome to Thinking Like a Lawyer with your hosts Elie and Joe Patrice, talking about legal news and pop culture, all while thinking like a lawyer. Here on Legal Talk Network.
Hello, welcome to another edition of Thinking Like a Lawyer. I'm Joe Patrice from Above the Law. I'm joined by Elie, who is not from Above the Law. How are you?
Let's go Mets! We did the right thing.
Yeah.
We got rid of our cheating manager before he managed a game.
Yeah.
I'm so happy.
Yeah. Well, as I said, not formerly of Above the Law, but still with us, Elie Mystal. So
you wanted to talk to...
Well, I figure you should at least make the announcement about like what you're doing. I think listeners would care.
I have formerly left Above the Law full time. I am now the justice correspondent at The Nation, which is great for me. But as I said in my departure memo, can't actually leave Above the Law, so I will still be doing this podcast because I love you guys so much. And honestly, like, who else would let me do a podcast where I get to talk to lawyers all the time?
Right. There we go. So what is your complaint of the day?
And who will let me get to do a podcast where we start every week with me complaining about something. This week, I have a lot of complaints coming out from over the holiday. So as regular listeners might know, I've been having some problems with my house. It is generally erupting in a spate of home improvement nightmare problems that will require hundreds of thousands of dollars over the next few years, most likely. In any event, some of that money should be taken care of by insurance. And this begins my problem. Here's a little fun scientific fact for you listeners. Do you know why humans have no hair? So, you know, all the other great apes are hairless. We're the hairless ape. You know why? It's because we are persistence hunters. What that means is that the way that we would hunt down our prey was basically run after it until it got so exhausted, it overheated, and then we would stab it with a pointy thing, right? It's called persistence hunting. It's how wild dogs hunt. It's how humans hunt, and we lost our hair because the ability for humans to sweat, to basically dissipate heat through our skin, made us, quite frankly, the most effective persistence hunters most likely the world has ever seen, although I'm not counting the dinosaurs.
Okay.
So it was an evolutionary advantage to be persistence hunters. And it is this evolutionary advantage that modern insurance companies have figured out how to use. They are persistence hunters for people with claims. So you have a claim, you're supposed to get money from your insurance, which you pay for, and they persistence you to death. Or at least they require you to persistence them to death.
Right, I think that's probably more, yeah.
To put another spin on it, right? They are exhausting. It's always another department you have to call, another person you have to get in touch with, and they know what they're doing so that one department says you can't file the claim unless you talk to the other department first. You call the other department. The very next thing they say is that they can't file the claim until you talk to the first department first, and they act like they're not sitting in the same goddamn room.
Right.
And we're 40-year-old homeowners. This ain't our first rodeo. Mm-hmm. So, when we call, we are taking down information. We're taking down, who am I talking to? What's your extension? Like, we're taking down all of that information so that we can transmit it to the next, call that we have to make. And it still doesn't matter. For these home improvement nightmares, they keep running us through not only the different departments, but then different, like, home improvement assessors that need to come out and be scheduled and whatever to come. And then the assessors come and they say, well, I can't assess until I get authorization from Department X. And it's all designed so that you give up and stop trying to get your money out of the insurance company. It is a scam. It is a plan. The amount of times in the past 2 weeks I have had to threaten somebody with litigation just to get them to answer my call truthfully. To the point where, and my wife and I do very good cop, bad cop on this, where my wife is the good cop, and she calls and she stays on hold and she's very nice. And then as they give her the runaround, which we know that she's going to get, I basically start screaming off camera and get louder and louder and louder as they get to the phone. And then I finally grab the phone and to whoever she's talking to, like, what is your name? And they're like, sir, why do you need to know? Like, I need to know who to name in my complaint. That's why I need your name. But you have to threaten litigation against some of these people to even get them to tell you the right form to fill out. Mm-hmm. It is persistence hunting. It is ridiculous. I hate the entire insurance industry so very much. And the only political segue I'll have for that is do not come to me with your sob stories about how Medicare for all is too expensive. Right? Just I do not want to hear that no mo.
Yeah, once you actually deal with an insurance company, you lose a lot of your yeah.
Because I'm just trying to get my house fixed, not my heart.
Right.
I mean, God forbid I had a medical problem and was dealing with this. I wouldn't be able to play bad cop because my heart would be too weak to take it.
No. Though that's fair. I'm sorry you're working with insurance companies. They are bad. There was a former, I won't name who, Southern District of New York federal judge who privately informed his clerks every year when they came in that it's important for you to understand that in this courtroom, the insurance company is always wrong. And I don't necessarily think that was a bad prejudgment situation or a bias situation. I think that was probably just born out of years of experience.
Accurate.
Anyway, well, we have some people to thank. So we'll begin with today's episode was brought to you by your adorable pony, who's very mad at you and thinking of jumping the fence. All because you're still at the office slogging through an endless doc review project. Make better decisions, keep your pet, and work smarter with Logical, e-discovery software that gets you started in minutes. Rein in your e-discovery challenges. Create a free account today at logical.com/ATL. That's logic with a K. CULL.com/ATL.
I was thinking, what do ponies do? Do they eat carrots? This is going to be a salt lake.
See, this is what's fun about these ads is now you actually think, because you know the format, once you hear the animal, you're trying to work out. Yeah. What I'm going to do next.
Right. That's fun for the listeners?
Yeah. I mean, I don't know, but it's fun for me. And frankly, that's really all I care about at this point. So with all that said, let's begin our show. So we're joined by some guests today from Edelson PC. I want to bring them in and talk about some of the work that they've been doing there. So I'll just introduce everybody first and then start asking some questions. So we're joined by Chris Dore from Edelson, as well as Aaron Lawson and Sydney Janzen. How's everybody doing today?
Hey, guys.
Doing good.
Good.
Thanks for having us.
Great.
You guys do plaintiff's work. Can any of you help me sue my insurance company?
Would love to, sure.
Talk to us after the show.
Fair enough. So, so Chris, let's talk a little bit about the firm. Longtime listeners of the show, I mean, we've had Jay on here before, so longtime listeners have heard a little bit about the firm before, probably. But just in case, let's assume we've gotten some new listeners in the last several years. So talk to us a little bit about the work that Edelson does in particular. I mean, Elie's already kind of foregrounded that there's some plaintiff work there, but talk a little bit more about that.
Sure. Yeah, the primary work we do is plaintiff's work in the class and mass action space, as well as representing a variety of different government regulators. We, I think, established ourselves in the industry focusing on privacy and technology, but have significantly expanded our practice over the years as our firm has grown, our practice has grown. And, we do everything from representing families that were impacted by the Camp Fire in California to representing former NCAA football players that are dealing with the long-term effects of concussions, as well as continuing to work in the privacy and technology space and kind of push the boundaries there.
Yeah, that's one thing that I've attempted to do in my work, and I don't know how well I've done it, but there's, for political point scoring, there are people who always bash plaintiffs and mass action lawyers, but I always try to use different terms than, trial lawyer or plaintiff's lawyer. As much as I can, I try to talk about public interest lawyer or something like that, because in a very real sense, a lot of the claims that you're bringing are more about advancing public rights that just wouldn't have any other, there wouldn't be any other way for them to be redressed other than the kind of work that you do.
I think that's absolutely right. We view ourselves as pursuing what, a government regulator might do if it had more time and more resources available to it. And the system is set up to incentivize us through the contingent fee system to be able to pursue that and bring cases on behalf of people that otherwise would never be able to pay for it or would choose to pay for it.
Yeah. I mean, there's that famous Posner quote about the alternative to these sorts of class actions would not be a million little suits. It would be 0 suits, that just no one would actually do it.
That's exactly right. Yeah.
Yeah.
And I think the point that you're making about how the system is set up this way is also an important one that people forget. Like that the way that we design certain laws and certain regulations, they are reliant on the class action to point out problems, to point out weaknesses, to point out issues within the system. The system does not have I shouldn't say any other. The system has very few other ways to actually address long-term structural problems in our either regulatory structure or general statutory structure without the class action.
Yeah.
That's right. Yeah.
So I want to ask so we've written about you in the past, and one of the most recent stories that I've written about the firm that I wanted to talk a little bit more about is I wrote up a rap video that you all put out, which was great, but it was more than just this rap video. It was part of a broader strategic turn for you all, which is the creation of this Edelson creative work and the podcast, the Non-Compliant podcast. So what's going on with the Edelson creative side?
We for years and years have had creative interests that we have pursued primarily internally. We like to think of ourselves as creative lawyers, and that the work that we do and the way that we approach things is different and unusual, and we like to come at things from first principles, and we apply that to just how our firm functions and the social aspects of it as well. And we want to find new outlets for it. Some of it's purely to entertain ourselves internally and to have fun at our holiday parties and things like that. And some of it is a way to kind of convey messaging to the world around us about how we view things and how we see ourselves in that space. And so some of it is comedic, some of it's musical. And then the podcast, like you said, Non-Compliant, which we have a couple episodes already out and a couple more that we're recording, we think is a really fun platform. Jay's hosting it, and there's a lot of really interesting conversations going on. Some of them are very legal, and some of them you'll see are not so legal and are addressing more societal questions and interesting topics like that. And so we're having a lot of fun developing that and finding new guests to kind of bounce around interesting ideas with us.
So confession time. When I was in law school, I continued my performance career. I did the law school parody all 3 years that I was in it. That I was in school. I was a writer for the show. I kept my performative aspect up. And one of the ways that I justified it to my mother, who couldn't understand why I was still, literally acting in plays as opposed to, I don't know, trying to get on law review.
Yeah. I mean, that was a valid question.
For instance. She wasn't wrong to ask. I mean, like, my mom's smart lady. Well, one of the ways that I justified is that, I've saw one of the reasons why I was interested in law was the performative aspect of it, right? And, I'm one of those kids that did mock trial in high school, and although I didn't do moot court in law school, I knew a lot of kids did. There is, I think, the law attracts, as opposed to medicine, for instance, the law attracts people who do kind of disproportionately want to perform, want to get up and be, even for a moment, the center of attention, and yet the practice of law for so many people so often is kind of solitary. It's a very quiet profession. You spend a lot of time in documents, in notes, in books, in research, and comparatively very little time kind of performing your trade in perhaps the way you thought you were going to when you were in college or law school. So with your Edelson Creative Program, do you find that what you're doing is giving an outlet for people who kind of thought they were going to be more kind of on stage or center stage? Or do you also find that as, plaintiffs' attorneys or however you want to call it, that some of these creative aspects really are helpful for people who at some point will have to be in front of a jury or at least in front of a judge?
That's an interesting approach to it all. I don't think
I've gone deeper than intended.
At its heart, we're looking to entertain ourselves and to have fun and to change up the atmosphere. Everything that we try to do in the operation of a law firm is to try and make us not like most law firms out there, and provide opportunities, legal and non-legal, for people to explore that. So in some cases, yes. My partner Ari Sharg, who appears in that rap video and wrote it, had a career that never launched, and it launched here. He is incredibly talented and has a lot of fun putting that stuff together. I love movies, I love TV, and so I've done some of the acting myself and directed most of the work that we've done, and done a lot of work with our cinematographer. And that for me is a great outlet. It's something that I enjoy doing, and to be able to do it at work, and to incorporate other folks that we work with, and have a lot of fun with it. Our fall is often wrapped up with brainstorming and having fun thinking about this and filming this kind of stuff. And as I said, mostly it's been for internal use, but some of it we've shared, and we think people enjoy it. And so I don't think this is training to put people in front of court. I think this is more about who we are, and just the culture that we build, and having fun together, and being friends, frankly. That's the type of the firm we have.
Yeah. Well, and it's a culture here. Let's see how this works as a transition. All right. See how this is. So that's a culture that actually, it seems though you somewhat share. You do a lot of tech work. You share that with a Silicon Valley style culture of having a little bit of fun along with the work. And one Silicon Valley sort of organization would be Facebook. So now that's going to be my transition. So
it's a pretty good transition.
Yeah. So I mean, as transitions go, I mean, this was tough. I feel like. All right. So Aaron, talk to us a little bit about the work you've been doing. You've been working with Facebook. I guess maybe not with, it shouldn't be the right word, but tell us about privacy and Facebook.
Wow. Oh, that's a huge subject. So,
or at least your corner of it, maybe.
Right.
Yeah.
So I think though that this is a good transition, because the Facebook case really, I think, kind of is a very good exemplar of some of the sort of Silicon Valley things that we pride ourselves on, both having the tech expertise and thinking about these problems in kind of a different way, but also relying on younger lawyers and people who might have different and new ideas. I mean, out here in San Francisco, we call them disruptors, but people with different ideas about how things should be done. And the case began, 6 years ago, when somebody who was then an associate found this Illinois law, the Biometric Information Privacy Act, that really hadn't been litigated much, if at all. And he kind of kept that in his back pocket. But because he also had some tech expertise, he was able to kind of look at what Facebook was doing with photos and noticed, hey, this law seems to apply to what Facebook is doing. And as an associate, proposed this lawsuit, which is now kind of a big deal. And so
just a bit.
Yeah. And so my piece of it, which is, 5-6 years later, right, when I'm arguing the Rule 23F appeal, is, this also, I think, is a culmination of the same kind of thinking. So if I could switch to a different case, right, we had Spokio up in the Supreme Court 4 or 5 years ago. And at that point, we're in the Supreme Court. Oh my gosh, this is such a big deal. Spokio, right, we have these privacy cases, and you're often met with skepticism from judges who are like, what is really going on here? I mean, why do you care? And so Spokio, I think a lot of people in our section of the plaintiff's bar, we all sort of collectively held our breath when Spokio went up to the Supreme Court. So we associated with someone who knew what they were doing at the Supreme Court, but we watched them work, and then our younger associates fanned out. And this is an argument we saw in a lot of cases. And we relied on these young associates, including myself, to brief it and argue it in a bunch of other cases. So in the last 4 years, we've developed a pretty deep working knowledge of those issues. Class certification, obviously, is something that's a procedural step we hit in a lot of our cases. And a few years ago, I just offered to work on class certification in one of our cases, did so successfully in that case, and have continued to do that. And even though that's a really big step in a lot of our cases, as an associate, I'm given that opportunity and that responsibility. And so this big Facebook appeal comes around. It's probably the biggest class certification fight we've had in a long time. It's probably the biggest Article 3 fight we've had since Spokio itself. But because I've been working on these issues, I get to stand up in front of the Ninth Circuit and argue it. And, you know, I think I blacked out a little bit. I don't remember the argument at all. I'm a little afraid to go back and listen to it or watch it. I've listened to all my others, but I don't want to know what happened. You know, we won the appeal, and that's good enough for me. But you know, it presents a lot of interesting issues about how you sort of think about what the harms are in these privacy cases, because you know our traditional understanding of harm is, you know, to put it bluntly, blood or money, and that's really not what you're dealing with here. But I think recently, especially, we've had some success convincing people that, look, these companies are using data and maybe manipulating you. I mean, this is sort of in the zeitgeist now, that especially following some of the revelations after the 2016 election, that, look, this data is out there and it's being used by companies in ways you might not understand. But some of this is governed by laws that are on the books, and it's up to us to enforce those. So it's pretty exciting stuff, to be honest.
I just want to, we have a lot of listeners who find themselves as associates in major law firms. Go back through a little bit. Sorry, that part of where you're the associate arguing in front of the Ninth Circuit. Like you went a little bit fast, I think, for me at least. Like you developed an expertise in class certification, which so you wanted to do it, and then you say you work on this case, you're working on that case. Now this major case comes up, and you're the go-to lawyer on class certification in like, how does that happen?
It is pretty crazy, but that's sort of our attitude, you know, that I was on the front lines of these fights in a number of cases, and I did help. I didn't appear in the district court. I have when you appear on district court dockets, all of a sudden you're on big reply all email chains, and I'm just not about that. But I did do some ghostwriting, when we got to the class certification stage in the district court. But I've developed an expertise, and I've been successful enough in drafting and in occasionally arguing these motions. And this is actually not the first Rule 23F appeal I'd argued, but it's also now not the only one I've argued successfully. That when it came time to argue this case, that the partners at the firm put their trust in me, and I really appreciate that. It makes it a lot easier to come into work when you know that you get that kind of trust from the people who are in charge, and it is really nice. But in this case, it was incredibly intimidating. I mean, it's definitely the biggest class cert fight we've had in some time. The Article 3 issues are obviously, they're in front of the Supreme Court right now. And I was really nervous, but this is, if you're going to invest in associates, this is kind of where it leads you. And for the moment, at least, that bet has paid off.
Yeah. No, that's great.
And if I can just jump in here.
Yeah.
Aaron's being modest here, where he is, a little bit describing himself as having just stumbled into this, and we said, okay, yeah, go ahead. You can this is God. He has done, ever since he's come to the firm, he's done incredible work for us. He's a fantastic writer, and his oral argument on Facebook was, we all watched it. We all had it up in our conference room, and it was an amazing thing to watch, and there was really no doubt in our minds sending him out there. But it's because it's also not the first time we've ever done this. It's not that we just took a flyer on an associate for the first time in this case. We have been sending associates to court generally, constantly, forever. But we've also been sending associates to circuit court arguments around the country. Someone we just made partner this year, Ben Thomason, argued in the 11th Circuit years ago when he was a first or second year. And he won. And it's a groundbreaking case in the privacy world about data breaches and overpayment. And so this is just at the core of who we are, to be putting essentially people into positions where they are the best at whatever they're doing. And if you're the most knowledgeable person, be it in a mediation or on a call with opposing counsel, or if it's going to court, it doesn't matter what year you are. It doesn't matter if you're a partner or an associate. We want whoever is in the best position to make an argument, to answer a question, to be the person who's there. And that's our philosophy.
And I guess there's something to be said for being on your side of the V there, because I talk to big law partners who do a lot of defense work, and they say the reason they don't let associates get that sort of face time with the court is because they'd frankly love to, but then you have to turn around to whatever corporate in-house muckety-muck you're working for and say, oh yeah, no, I know I'm the person you're paying $1,000 an hour, but I'm going to let the first year try it. And they just don't feel comfortable doing that. But that doesn't mean they say the first year is absolutely capable of doing it. In fact, maybe more capable because they've done all the work on it. But I just can't report to the in-house folks that way. Whereas on the class action side, in a lot of ways, you're directing how it works. And so you have a little bit more freedom.
Yeah, and something you said there also, I mean, it definitely applies to us, right? Your younger associates, in any case, are going to be the ones kind of on the front lines and driving the litigation forward. They'll be, knee deep in the documents or knee deep in the research that's being done on a motion to dismiss because they're writing the first draft of whatever. And to us, it just makes sense to have that person also get up and explain whatever it is that needs to be explained to the court, because that's one, it means two people don't have to learn the same thing. But it also, it ends, you can put someone like me out in front of the Ninth Circuit in our Facebook case and be confident, I guess, people were confident, that the outcome will be okay.
Mm-hmm.
I've noticed more and more, too, that a lot of district judges are starting to have standing orders that note that they want younger associates in court and kind of admonishing big law partners when they don't bring them or don't put them in a speaking role in the courtroom, which I think is awesome.
Yeah.
Yeah. And Joe, to your point, I think there's some truth to the statement you made about big law making decisions about associates, but I don't think that's the full story. I think that's a nice excuse for them to say we don't trust them. And it's harsh, but I think it's unfortunately true that there's a lot of incentives to keep the work either at the top from a monetary standpoint, or they just simply do not trust young associates, and it creates a terrible problem. If you talk to Jay about this is a lot of his thought process on how he developed the firm, is that when he was himself a first-year associate at a big law firm, there was no trust, there was no effort to put them out there, and there was a lot of reasons for that. And he found that the people around him were scared. They were scared of going to court. They were scared of confronting opposing counsel. They were scared of all the things you need to be able to do as a lawyer, because they hadn't done it for years. And then all of a sudden they're asked to do it at a later time. And our philosophy is the opposite. Is that you're going to court as fast as we possibly can get you out there. We have a rule around here that it's like, you get sworn in, you have the next available court date, you're going to court and you're speaking. Sometimes it's that day if we can manage it. And it's tearing that Band-Aid and saying, look, you're competent, you can do this, and there's nothing, to be scared of, and to get comfortable in that position so that by the time, Sydney is a couple years in and has gone to court, like she absolutely has lost track of how many times she's ever been to court. It's just second nature.
Well, that's a good way of pivoting. So we've talked about working on tech cases. Sydney, you've worked on a high-profile case that's not so much in the tech space. Can you talk a little bit about what's going on with the sports performance case?
Sure. Yeah, this is definitely not our typical type of case, but certainly in recent years with Me Too and everything, sexual abuse has come to the forefront. So what this case is about is there's a youth volleyball coach here in the Chicagoland area who's one of the most prominent youth volleyball coaches in the country. And there are allegations that he sexually abused his players going back decades. And so this came to our knowledge. I think anyone who's researched our firm might have found that we like to play volleyball here. Jay loves volleyball. We've got a volleyball court at the office. So Jay heard of this, and we were just kind of brainstorming on, is there anything we can do? The women who have come forward, those claims date back to the 80s. So the statute of limitations had long run on those claims from a criminal or even civil perspective for those women. But we decided to take a route relying on our class action consumer protection backgrounds, and found that we had actually pretty good claims under the Consumer Protection Act here. And there's also a statute dealing with contracts with gyms or fitness facilities, where now we have a lawsuit on behalf of parents whose children play volleyball at Sports Performance Volleyball, and specifically for this coach. And basically the claim is a simple consumer protection claim. We wouldn't have brought our kids to be coached by this guy if we had known that he had a history of sexually abusing his players. And it's certainly been eye-opening. It's been just amazing speaking to these women and knowing how brave they are to have come forward, and knowing in some way, shape, or form we're trying to help them tell their stories, give them a platform, but also kind of hold this coach and his facility accountable.
Wow. I mean, that's usually the kind of work you hear people doing pro bono, right? Because like that's
Like, yeah.
right. Like you when you are fighting so often, I think, especially in the world of like high, big firm, high pressure law, when you're fighting the good fight, so often you're kind of forced to fight that fight for free.
Well, to be clear, we are bringing this case pro bono. We are not taking any fees for this case. It's just something we believe in really strongly. And so, it's definitely not our typical pro bono case here. We do encourage attorneys to pursue pro bono cases that mean a lot to them. But this was definitely something that everyone could get behind, and it just felt like the right thing to do and something we really wanted to do.
Yeah, and this case has really been a focus of the firm, and Sydney's been leading it. And it's not a typical pro bono case that a lot of big firms look at it and push down to younger associates just as to keep those wheels moving. This is something that as Sydney said, Jay is very passionate about, and the firm is passionate about, and has been honestly one of the most heavily litigated cases that we've had. There has been so much action in this case, and we've gotten class certification. We're dealing with summary judgment, and our expectation is this case is going to trial in federal court here in Chicago, and we're really excited to keep pushing it and to get to the right resolution.
Mm. Obviously, the cases that most come to mind about this are all of the cases surrounding the gymnastics scandals. It just seems as though there might be deep-seated problems within youth coaching in sports, and I think there's something to be said for coming up with a novel approach for how to get at these issues, even where there are statute of limitations problems, is a real service, not just to these women and these parents who are involved, but to others who will pick up this mantle potentially if more problems are discovered elsewhere.
Absolutely. I mean, we're hopeful that, moving forward, if this happens to anyone else, which we obviously hope it doesn't, but, our eyes are open to the fact that there is a rampant problem in youth sports today with these sorts of things. We're hopeful that this case can kind of act as a blueprint for, ways to hold these folks accountable moving forward.
Well, great. Well, thanks everybody for joining. This was really useful, and I think it's good. We have our audience is kind of all over the place, but we do have a good deal of vocal folks who reach out to us who are in the pre-law space trying to figure out where they want their law school career to go. And I think a lot of times when you show up in law school, you're funneled down the path towards being at some defense on the defense side. And I think it's good to hear what's going on the other side of things and the sort of work that you could be doing if you chose to go on more of a plaintiff's route.
Yeah, it's a good time on this side of the V, and law schools and you guys too would be appreciated to make sure that the law students know that there is another half of the world out there.
Yeah, and that's why it's been really good over the years. I'm not that we don't talk about other firms, but you've always been very forward about bringing stories to us and stuff that you're working on so that we're in a position to talk about it. Some others don't publicize their work in in ways that meet our radar all that often. So it's been very good of you all to keep us in the loop as to what the work you're doing.
Yeah, happy to do so.
Well, great. Thanks, everybody, for listening. And if you aren't already subscribed, you should be doing that. You should go give us reviews, not just the little stars, but write something. The mere act of writing things helps those algorithms figure out that we're a law podcast that's out there that people should listen to.
Oh, algorithms.
I mean, I'm sure it's something that violates one of these rules. But the point is, you should be doing that. You should also be reading Above the Law, obviously, following, and The Nation, I guess I should start saying now. You should be following us on Twitter. I'm at Joseph Patrice. He's at Elie NYC. You should be listening to all the various offerings of the Legal Talk Network, as well as The Jabot, which is Catherine Rubino's podcast here at Above the Law. And with all of that said, and thank you. Oh, and thank you to Logical for sponsoring and giving me an opportunity to come up with a different animal pun every week. So thank you. So thanks, everybody, and we'll talk to you soon.
Peace.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. You can also find us at AboveTheLaw.com, ATLRedline.com, iTunes, RSS, Twitter, and Facebook. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.